Ready? Start. Faced with the grave situation, the accused did not feel satisfied with the initiation of criminal prosecution by the police and preferred the present petition for quashing the impugned FIR and all other subsequent proceedings arising therefrom, invoking the provisions of Section 482 CRPC. The case set up by the accused in brief insofar as relevant was that there is no evidence on record whatsoever to indicate that the kerosene was meant for sale or any actual sale had taken place. Mere possession of kerosene in itself was stated to be not an offence in view of the Kerosene Order 1993. According to the petitioner, that in the present case the search and seizure were not in accordance with the provisions of the EC Act. Neither the police was competent to seize the kerosene nor empowered to file the challan against the accused. On the strength of the aforesaid grounds, the petitioner sought to quash the impugned FIR and all other subsequent proceedings arising therefrom, as described herein above. The respondent refuted the prayer of petitioner and filed the reply inter alia, taking certain preliminary objections of maintainability of the petition, cause of action, and locus standi of the petitioner. The prosecution claimed that the challan has already been presented in the court, and as the petitioner has committed the indicated offences, therefore no ground for quashing the criminal prosecution is made out. Instead of reproducing the entire contents of the reply, and in order to avoid the repetition, suffice it to say that State of Punjab has reiterated the allegations contained in the impugned FIR. However, it will not be out of place to mention here that the respondent has stoutly denied all other allegations contained in the main petition and prayer for its dismissal. Having heard the learned counsel for the parties, having gone through the record with their valuable assistance, and after bestowal of thoughts over the entire matter, to my mind, the instant petition deserves to be accepted in this respect. Sequely, it is not a matter of dispute that it is well settled principle of interpretation of statute that the words of an enactment are to be given their ordinary, popular, and natural meaning if such meaning is clear and unambiguous. The effect should be given to a provision of a statute in the same manner, whatever may be the consequences. The basis of this principle is that the object of all interpretations being to know what the legislature intended. Whatever was the intention of the legislature has been expressed by it through words which are to be interpreted accordingly, because the intention of the legislature can be deduced only from the language through which it has expressed itself. If the language of a statute is clear, the only duty of the court is to give effect to it, and the court has no business to look into the consequences of such interpretation. The court is under an obligation to expound the law as it exists. Stop and over.